All right. Well, thank you for coming to our channel to hear the last of our Student Scholars presentation for this calendar year. I'm A.G. Harmon of the Columbus School of Law at the Catholic University of America. And on behalf of the faculty, let me thank you for zooming in to the last of our presentations in this year's Student Scholars series. Please stay on mute until the presentation and response are over. I'll open the floor to any questions, and you can signal that to me and I will recognize you. This series, just so everyone knows, as I'm constantly reminding them, was instituted 16 years ago in order to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by third-year student Sam Bonfiglio. Before I introduce Sam, however, a few words about the respondent to his presentation. Henry Wixson is the former chief counsel of the National Institute of Standards and Technology, a position he held from 2009 until his retirement. Prior to his time at NIST, Mr. Wixson was a partner at Wilmer Cutler Pickering Hale and Dorr, LLP, and was awarded his JD from George Washington University. We thank him for being part of the program today. Now I'll introduce our student scholar. Sam Bonfiglio is a third-year day student at the Columbus School of Law. He graduated with BSBA, ABSBA in finance from the University of South Carolina in 2021. During his time in law school, Sam has served as an associate editor for the Journal of Law and Technology, as well as holding an executive position with Italian American Law Students Association. Sam has worked internships with both Pfizer and Financial Industry Regulatory Association and hopes to pursue a career in securities after graduation. Sam became interested in his topic because he saw a tweet that claimed that McDonald's ice cream machines were always out of order because of copyright law. Now, believing that to be true, he read the article and soon found himself in the deep rabbit hole of Section 1201 and its inequities. So now I'm going to turn the floor over to Sam Bonfiglio. Sam, let me make sure that I turn this over to you to make you the host. You are now the host. Sam, we're looking forward to hearing from your article, about your article, Fight for Your Right to Repair.
Perfect. There we go. I think everyone can see it, correct?
We can see it just fine.
All right, perfect. Let me get into... Thank you, everyone, for coming today for my presentation here on my article that I wrote for the Journal of Law and Technology, Fight for Your Right to Repair. First, I want to thank Professor Harmon for allowing me to speak today as part of the Student Scholar Series. And I'd also like to thank Henry for all the work he did and being my expert reader and for taking the time out of his busy schedule to be here with me today to act as my respondent. So to begin, I'd like to start with my abstract. My article brings to light how the DMCA, the Digital Millennium Copyright Act, in its current iteration, implicates consumers' rights to repair their purchased devices. It argues that Section 1201 of the DMCA unfairly impedes upon both a consumer's right to choose their desired service location, as well as their right to attempt service themselves. It further argues these restrictions ultimately force consumers to use a manufacturer's licensed channel of service, effectively granting them a monopoly on this. The article advocates for the reintroduction of the Freedom to Repair Act to amend the DMCA to ultimately commercialize the market for these services while simultaneously protecting a manufacturer's interests. So here I wanted to give a quick overview of our agenda for today. I don't know where the right half of my slide went, but I can get off the cuff here. So we're going to begin with a quick corollary onto McDonald's, how I got interested in the topic, and that'll be used as to bring into light the DMCA. We'll then move into an overview of the DMCA. We'll talk generally about the DMCA and Section 1201 specifically, and how Section 1201 and the right to repair laws interact. We will then look at a few case studies around Section 1201 to point to the inequities that Section 1201 can bring. And then we'll look at the right to repair, what it means, and how the state legislature has begun taking action for right to repair legislation. We will then turn to the Federal Freedom to Repair Act, which attempted to amend the DMCA. It was ultimately unsuccessful, and we'll look at why. And then we'll conclude with me advocating on how I believe we can hopefully end up amending Section 1201 of the DMCA to allow the right to repair. So let us begin with McDonald's, everyone's favorite fast food joint. If you see in the top left, you'll see McDonald's ice cream cones. If you've ever gone to McDonald's and tried to buy an ice cream cone, I would honestly wager 50-50 that they told you something along the lines of, "I'm sorry, our ice cream machine is out of order. We cannot do that for you." If you'll see in the bottom left, it has become such a problem that there are memes in this country. As you can see, that is Daenerys Targaryen with the McDonald's hat on, eagerly awaiting to tell a customer that they cannot get their ice cream. And in the top right, you will see a ice cream machine that is manufactured by Taylor. These aren't McDonald's ice cream machines. These are manufactured by a manufacturer named Taylor. That'll be important later. And if you didn't believe me that this is such a problem and that these machines are constantly out of order, this is a map of the greater Washington, D.C. area. All of those dots represent a McDonald's location in D.C., Maryland, or Virginia. Those red dots represent a McDonald's location that has an ice cream machine that is not currently functioning. I did not take this data myself. I did not go around and plot every McDonald's onto a map. There's actually a website entitled mcbroken.com that actively monitors every McDonald's in the country to see if their ice cream machine is broken. It is that big of an epidemic, I promise you. So you might be asking yourself, why? Why are these ice cream machines always broken? Is it because McDonald's employees don't care to fix the machines? Is it because McDonald's tells them that their ice cream machines sales are low, so they don't bother to fix them? The answer is no. The answer is because Taylor, the manufacturer of these ice cream machines, has installed certain access control locks into their machines that do not allow a third-party technician to bypass these locks without violating Section 1201 of the DMCA. So let us look at the DMCA. The DMCA was signed into law by President Bill Clinton in 1998, and the focus was to address the rather inefficiencies, how the current iteration of the Copyright Act of 1909 was not effective in giving the correct protections to copyright holders. This was after large talks on the international scale, WIPO treaties, which were large international-based treaties that sought to bring the whole world up to the standard to protect copyright interests. And so it amended the Copyright Act of 1909 in three specific ways. It added Section 512, 1201, and 1202. 512 just provides a safe harbor for online service providers hosting copyrighted materials. 1201, the one in bold and the one we'll be talking about today, introduced measures to protect against the circumvention of access controls and made it unlawful to produce and distribute tools to do so. Don't worry, I'll explain what that actually means in a second. And Section 1202 introduced measures to make it unlawful to conceal infringement. So as I said, Section 1201 is the crux of right to repair laws. Section 512 and 1202 right to repair laws do not touch. And so 1201A1A is what is colloquially referred to as access controls. 1201 states, in pertinent part, that no person shall circumvent a technological measure that effectively controls access to a work protected under this title. I know that might not really sound like it makes much sense, so I'll give a real world example. Imagine you have a locker at school and you put a lock on it. Imagine a thief comes at night and they attempt to break into your locker. The act of breaking the lock is a violation of Section 1201A1A in the copyright sense. So go back to our McDonald's example. If a McDonald's ice cream machine spits out an error code and shuts down because of it, if McDonald's tried to get a third-party technician to come in and they bypass that error code, they would be in violation of Section 1201A1A. They would be in violation of the access controls that Taylor, the manufacturer, put into their devices legally to stop third-party technicians from servicing them. The other half of right to repair laws and what they touch are copy controls found in Section 1201A2. 1201A2, in pertinent part, essentially says that no person shall manufacture or traffic any technology that can circumvent an access control. So going back to our lockpick example, if in that scenario you were a manufacturer of lockpicks, you would be in violation of section 1201A2, in violation of the copy controls. And so to harken back to our McDonald's discussion, if you produced a device that could bypass Taylor's error codes and you manufactured it and distributed it to, let's just say, McDonald's, you, as that manufacturer, would be in violation of section 1201A2, in violation of their copy controls. And so I'd like to highlight how this actually goes into effect and what these actually mean and how these affect these companies. So as I said earlier, Taylor installs these access controls onto their McDonald's ice cream machines. And so anytime a McDonald's ice cream machine shuts down for any sort of error code, it can just be because it needs to be cleaned. And there's sometimes that these cleaning processes spit out an error code, and a McDonald's employee is powerless to do anything to fix it. They must call a Taylor technician. A repercussion of that is lengthy downtimes. When I was researching my article, I found that it can take up to 3 months for a Taylor technician to come and fix an ice cream machine. 3 months for an ice cream machine. All those 12 ice cream machines around the McDonald's area might be down for 3 months. So you might want to look at that map if you're looking for an ice cream from McDonald's soon. It might not be there. And the other repercussion of it is costly repairs. This one has actually shocked me. I want to be a lawyer. It's great money, but it might be better money to be a Taylor technician. They charge $300 every 15 minutes to repair a McDonald's ice cream machine. 15 minutes, $1,200 an hour. And I might be reading between the lines a little too deeply here. I think the reason they charge per 15 minutes is because it takes no time at all for them to bypass these access controls and to essentially have the machine running in no time. iFixit, which is one of the largest public interest groups for right to repair laws, they themselves got the access to a Taylor ice cream machine that had an error code. They also got access to one of the devices that can bypass these codes, and they were able to fix the machine in 5 minutes. They just said it was a jumbled mess of error codes that Taylor specifically made just so it would make it extremely difficult for anyone else to bypass these access controls, making you go to Taylor. And the result of that, obviously, is an uncompetitive nature in the third-party access to this repair. McDonald's has their hands tied. They can't go to anyone else. They have to go to Taylor. They have to pay $1,200. And ultimately, this is something that a third-party technician with his or her knowledge, could fix in 5 minutes for $10. Or you could go to Taylor, 15 minutes for $300. And that's access controls. And so Universal City Studios, Inc. versus Ramirez is a great case study that shows the inequities that can be brought on from copy controls. So Eric Corley was an individual who purchased, let's just say, a Pirates of the Caribbean DVD from Universal. However, he had a Linux operating machine. He had a machine that had a Linux operating system. So he had a Microsoft computer, but he installed Linux on it to operate off of. Unfortunately for him, for whatever reason, Universal did not allow these DVDs to play on a Linux operating machine. They could play on Microsoft, they could play on Mac, but they would not play on Linux. What reason for that? He doesn't know. We don't know. But Eric Corley decided to fix that. So he bypassed the access controls, the 1201A1A, just himself. He just hacked through them. And through that, he reverse engineered a way for anyone else to be able to do it. And he created a program and made it available online for anyone else who wished to download it. Meaning anyone with a Linux operating machine could go online, download his program, and then they would be able to play these DVDs on their operating system. A DVD they purchased to play on their operating system. Universal Studios found out about this, brought a suit to enjoin him from further developing his program and distributing it, and they were successful. I don't mean to bring this case study up to say that this was unjust. This was very just by the letter of the law. He certainly was in violation of 1201A1A and 1201A2, but violated both the access controls and the copy controls. But I use this more to demonstrate the fact that the statute can bring about inequities do you really believe that is when the DMCA it's grounded in fair use? Is it fair that Universal Studios can tell you can't watch it on Linux? Does that really make sense? That that is what I seek to bring to light. And so I'd like to move into the right to repair. Generally, what it is it refers to the right of the owner of an electronic device to have access to the information necessary to diagnose and repair their devices, as well as the right to have their device repaired by a technician of their choosing. So right now, at the state level, all 50 states are at least considering a piece of right to repair legislation. And that is as of February 2025. So this is very recent. This is right now. This is happening. And I believe it was, I forget which state. I want to say New Hampshire might have been the last one to consider. I'm not sure. But as of right now, there are 6 states that currently have passed right to repair laws, and all 50 are at least considering them or have considered them. But there's still a long way to go in this fight. And still, although I'm happy that at the state level right to repair legislation is being passed, my goal is to have it at the federal level. So let us look quickly at the Freedom to Repair Act in its essence as it was proposed at the federal level. As you can see, it proposes to amend Section 1201 of Title 17, the Copyright Act, the Copyright Code, to not make withstanding Section A1A, it would not be a violation for a person for the purpose of diagnosis, maintenance, or repair to bypass and access control. So harkening back to McDonald's, this would not make it unlawful for McDonald's to go to a third-party technician to have them repair their Taylor ice cream machine because it would be for the diagnosis, maintenance, or repair of the device. And notwithstanding, and then if you go to point 2, you can see that it would not make it unlawful to manufacture the devices necessary to otherwise get through these access locks. So this bill was brought in 2022. It received 3 co-sponsors, 4 sponsors total, and it got recommended and died essentially. And so the reason I believe it died is just because if you look at it, it's really short. That there are so many players that are affected by right to repair legislation that a simple 5-line amendment isn't going to capture all of the players that are at risk here. And the only carve out that was carved out into this act was for medical devices, which I think we can all understand makes sense. Medical devices should be only maintained by medical equipment managers, OEMs. And so this leaves me right around the recommendations that I would have to hopefully get a piece of federal right to repair legislation through. And the first part that I think is necessary is that you need to consider the OEM's concerns because they are valid and they are true. And when I was doing my research, the biggest thing that stood out to me is that there was never really a consideration for the OEMs and for the other side of the argument. It was always why we want right to repair legislation and why we deserve it. It was never why should an OEM fight against right to repair legislation? And their concerns are valid. Privacy. I mean, a lot of these pieces of technology inherently have a lot of information behind them, and in the hands of the wrong people, it can get distributed in a bad way. Safety. This is in 2 terms. Privacy as it relates to privacy, safety is an issue, but also safety in maintaining these pieces of equipment. For example, farm industry. A big pushback from John Deere, who is one of the biggest pushbacks against right to repair legislation, is that they don't want to be able to have a farmer get hurt repairing a 14-ton tractor and be liable for it because they gave them a 50-page handbook on how to do it. And that's not just for tractors. I mean, Taylor might have made the argument that they don't want a McDonald's technician potentially burning their hand if they access the machine during a cleaning period. And then a third concern is obviously intellectual property. None of these OEMs want their intellectual property in the hands of bad actors or anyone who they or their competitors. And if you can bypass these access locks and control locks, there are concerns that you might be able to dig into intellectual property behind these electronic devices. And the second recommendation I have is that the general public really needs to advocate more right to repair legislation because because there are so many high-paying players that are against it. Many industries would not personally would not benefit. They would not want right to repair legislation. Like I said, John Deere, one of the biggest against it. They make like 20 or 30% of their revenue every year is from repairs. They don't want to lose that. Of course, they're going to fight it to the death. So you're going to need farmers specifically in that industry to rise up against John Deere and say, "Hey, no, we believe we can get these fixes done." And when our tractor goes out during busy season and we lose $150,000 because it takes you 2 months to get here, when I could have fixed this in 5 minutes, and I see you coming here and fixing it in 5 minutes, we need that sort of public zeal to rise up. And two, with that is advocacy groups. They've been one of the biggest proponents of right to repair legislation. The Public Interest Research Group, PIRG, is certainly, if you look up right to repair legislation, you will certainly come across an article from PIRG. The Farmers Association is huge. They go in front of Congress constantly to advocate for their rights. iFixit is where I actually read my original article that got me interested on this topic. So I do believe that public advocacy can get right to repair legislation at the federal level passed. Thank you for sitting with here today through my presentation.
Thank you, Sam. And Sam, if you will turn the hosting duties back over to me.
I'm sorry, what is that under?
As under participants, you should, if you just press
Okay.
participants, you'll see the names, and then you'll go over to my name and just says, make me the host.
All right.
Okay, I will now turn things over to Mr. Wixon. Mr. Wixon, if you will conduct a response to Sam's presentation, and we'll let that go on for 10 minutes, and then we'll open things up for questions.
Very good. Can everyone hear me?
Yes.
Well, first of all, I want to thank you, Professor Harmon, and also obviously thank Sam for the opportunity to participate here. And not only that, but as Sam mentioned, I had the privilege of reviewing his paper while it was in preparation, and I know how much work he has put into it, and I appreciate the opportunity to be involved. As you had mentioned, my own background is in intellectual property law, so this is a topic that is of particular concern to me, although I will say that I find myself with a sudden urge to go out for ice cream here for some reason or other. But Sam, I'd like to ask a couple of questions to begin with about the idea of a right to repair. And I'll start by saying my fundamental training is as a patent attorney. And on the patent side of intellectual property, we have what is called the first sale doctrine. And the first sale doctrine in patent law basically says that the owner of the intellectual property, in that case, a patent, exhausts their right to control the patented product when it is sold in commerce, and that the purchaser, a bona fide purchaser, once they pay the patent owner's price for its patented product, has a right to do basically anything they want to with the product that they own. So they can tear it apart, they can reverse engineer it, they can repair it, they can do whatever they want to it because the monopoly, I hate to use that word, but the right to exclude that's granted by the patent exhausts upon its sale. The same principle applies generally in the context of copyright law. The problem in copyright law that we struggle with, and that perhaps was part of the genesis of the DMCA, is that once you have the copyrighted, in this case, it's fundamentally software, you can then continue to use it beyond your own personal use, which is our focus in the patent context. And so one of the reasons for the DMCA was to try and balance the right of the copyright owner to control their copyrighted, say, software from the individual purchaser or from others who would take that software and then continue to do work with it beyond the individual. So we have that balancing act. And as you pointed out, when President Clinton signed these amendments in 1998 to address Section 1201, that was an attempt to balance those interests. And the fundamental point that you're making, Sam, is that that it's out of balance, that the rights of the copyright holder now have exceeded the rights of the public and the wayfaring stranger who should be able to do more than they want to. One thing I wanted to ask is whether the DMCA itself codified any exceptions to that prohibition against circumventing access controls. So is it possible that there's a balance there within the DMCA itself that I'm not appreciating?
There is. It's a great question. There is the every 3 years there is a petition to the Library of Congress through note and comment to get an exception to the prohibitions against access and copy control locks if you can demonstrate that you're doing it strictly for repair purposes and don't have any nefarious intent to violate copyright law. So in harkening back to our McDonald's discussion, actually, it's pretty topical because they were just granted late last year, an exemption by the Library of Congress for the exact thing that I talked about, which is their ability to access Taylor ice cream machines and get inside. So that map that I pulled up when I researched originally this issue, it was a lot more red than it is today. And that is partially because McDonald's now has the right to both access their machines and to have access to the technology to bypass these locks. And this is a process that any consumer, any manufacturer, or not manufacturer, any purchaser of a technological device can petition the Library of Congress once every 3 years in order to get an exception. These exceptions are not permanent. They last for 3 years. And so you have to petition every 3 years. And that raises another problem, actually, that it's a tangential problem that I would like to touch, is that a lot of these rulemaking procedures, when you seek to go against an OEM and try to get an exemption to bypass these access controls, you're typically not going against the OEM. You're typically going against any copyright holder that tangentially benefits from the OEM's devices. So let's just say you're going against Microsoft and you have a problem with their Microsoft Xbox, the gaming device. Microsoft likely wouldn't show up to the note and comment to oppose you, but who would is the Video Game Association of America, the Entertainment Association of America, the DVD Association of America, all of these companies that have a benefit that they derive from Microsoft, and they wouldn't want you bypassing their Microsoft's access controls because you might access their own proprietary information. They're ultimately the ones who go to the Library of Congress and are the ones defending these other companies, these third parties, against consumers and against these advocacy groups who are hoping to get these exemptions. So while that's not the focus of my conversation, I do believe that's also an interesting, little rabbit hole to go down to why these companies don't defend themselves. They just advocate out to third parties who, defend their rights for them. I think that's interesting. But to go back and answer this question, no, or yes, there is a way to get an exemption. It is not permanent. They're every 3 years, and you have to petition the Library of Congress through note and comment.
Thank you very much for that, Sam. And I guess the follow-on question that occurs to me is why isn't that exception process enough? Why doesn't that solve the problem for us, for anybody who's actually interested in trying to fix their own ice cream machine? go to the Library of Congress, petition for an exception, and fix your own machine.
Um, so I'd actually funny enough, I'd like to take from my remedies class just a couple days ago when we were talking about injunctions. And so if you're seeking an injunction and there's a remedy at law, typically you would like the remedy at law. However, in this case, and when you seek an injunction, the reason you want an injunction is because they're just going to keep doing it and doing it and doing it. So if you're going to, let's just say some tortfeasor is, like they said, putting rocks onto your lawn. If they just keep putting rocks onto your lawn, you get a remedy at law and they have to pay you damages, they can keep putting rocks and they'll just go back and forth forever. But if you get a permanent injunction, they can never put rocks on your lawn again. The similar vein here is that Microsoft or anyone who seeks an exemption will have to go every 3 years for essentially eternity to keep getting the benefit of um, this exemption, and they will have to every time demonstrate that the same burden of proof, and every time they'll get opposed, and 1 year they might get it, the next year they may not. And similar to is that there's just too many players that might want these exemptions. The Library of Congress does similarly probably does not want to sit there forever and constantly hear every single person claim that they need an exemption. And I just don't believe it's a functioning system having the Library of Congress to sit down there and consider this every single time. So I do believe the best course of action would just be to have a sweeping federal legislation that covers it all.
Great. I appreciate that explanation there. I guess it does raise for me the question when we look at the right to repair legislation that you had provided to us, it's clearly a sweeping solution, right? It's a blanket solution. It fundamentally says, if you want to do this, go ahead and do this. And one could understand manufacturers objecting to that because it completely um, undermines the intent of 1201. Um, can you imagine any kind of middle ground if you were put in charge of drafting legislation, a new version of this statute or bill? Is there any way you could introduce, or have you thought about, could you introduce any kind of more balancing in the exception that's laid out in that legislation now that might mollify some of the concerns or reasonable concerns that OEMs might have with access to their copyrighted software, for example?
Sure, I believe you could certainly put intent-based language in there. So if you're intending, like they'd have some language that is if it's for diagnosis, maintenance, or repair. But I believe that there can be some more language about your intent and what your intent behind it is. Um, I I think the problem with just adding in, more or trying to strike a balance is that it's really hard. I'm trying to think. I've rattled my brain about this a lot. I don't know just what words or what clauses or how this might, how these balances are going to be struck, especially when I look at our last sweeping piece, the DMCA was the product of many a, it was a product of the Berlin Treaty or Convention or Berne Convention, or I'm sorry, I'm mixing up my conventions. I'm in the comparative international trade right now, and I'm mixing up my conventions. But this was a big international undertaking, and so I don't believe that it's just going to be as simple as putting in a few more clauses. I think it's going to need to be a big sort of referendum of sorts to really hash down everyone's worries and needs as it regards to getting exemptions for this.
Yeah, I think it's interesting your mention of the international treaties that exist right now, because I hadn't actually been thinking about that. But if anytime we start to address copyright in this country, we have to keep in mind, and it's the Berne Convention, as you said, that we have international treaty obligations, and we can't run afoul of those. I'd like to go into the weeds just a little bit on the ice cream example. And it occurs to me that one of the reasons that a tailor technician can come in and very, very quickly diagnose a problem with their machine is that Taylor, probably have made a significant investment in onboard diagnostics on that machine that allow you to, hook up to it and the machine tells you what's wrong with it and then allows you to fix it. So you don't have to go in there with, with two probes, testing the capacitors yourself. And so I guess one question that raises for me is, would it not be the case that Taylor has a right, given that nature of that investment in diagnostics for their own machine, to say, wait a minute, we're the ones who have made the investment in this machine. You, the user or the competing technician, should not have the ability to go in and take advantage, basically exploit our investment, and we get nothing out of it. And if one accepts that as an argument, is there a counter? Is there a way to solve that problem? Could there be some way to compensate Taylor for the investment they've made that allows their technician in 5 minutes to fix the machine, where otherwise you'd have to tear it completely apart and test each component?
It's a great question. So a lot of the state right to repair legislations, they don't just make it that these OEMs have to willfully give over these pieces of technology that allow you to bypass these access controls. Typically, you just have to make it available for sale. So Taylor would have to make available for sale the technology, whatever they would input into the Taylor machine. So they could sell that device to these technicians and to individuals, I guess. And that's in a way, how they can make their money. And let's just say accepting their argument that, we've invested all of this time and money into this. My response, I guess, would be that, that's your competitive advantage. You're Taylor. If McDonald's wants to make sure that they're getting the best service, they can go to you. You're the one who has all the information. You have all the code books. You made the machine. So that's the beauty of the free market is I can go to you if I really believe that you're going to do it the best, and if you charge a reasonable price for that. However, if a third-party technician can give me similar reassurances and charges me considerably less, then that's the beauty of a free and competitive market is that there should be competition in regards to this. And although I understand that they might put in a ton of research and money into diagnosing their repairs, as it goes for a lot of these companies, and once again, this is a totally separate rabbit hole, is that there's also an argument to be made that a ton of these companies specifically make their products extremely, extremely complicated for this exact purpose. That's an argument to be made. Once again, taking back John Deere over the years, and John Deere and all their competitors too, they've all begun to become extremely, extremely electronic dependent, and now they are extremely, extremely liable to fail for any host of electronic reasons that a farmer themselves would not be able to fix. They would have to get a technician who has the proprietary technology to put into your tractor to get the error codes and bypass the access locks. So while there might be some merit to the argument that these companies place a lot of money and time into making diagnostic repairs work, there also similarly might be that argument that they're doing this purposely to specifically make sure that they are protected by Section 12.1 of the DMCA.
That's an interesting thought, I think. And the farming example is particularly difficult to unwind, because if you follow any of the precision farming technologies that farmers are using these days, they are varying inputs by the foot while they're moving at 7 miles an hour over the land. The sophistication of the technology is simply astounding to me anyway, and all that goes into it. So finding that balance again between the investment in allowing the advantages, say, of precision farming, that all the electronics on a modern $500,000 tractor, and finding that balance between allowing the local technician to fix it and John Deere, it's a significant problem although there must be a solution somewhere. One question I have that occurs to me is that once you let a third party into your system under the Right to Repair Act, the federal law that we have, I mean, what happens to your warranty obligations once you let, the local technician in? What do you think? How do you think that should work?
Um, that's actually a great question. That's something I hadn't actually put any thought into how a warranty might work in that scenario if we are then going to say that there is this right to repair. I still believe that the warranty can be voided. It should be voided. I believe still a manufacturer can hold that right that, you know, while you can go and get it repaired and we will allow this repair and you can get it for cheap and do it whatever, you can still void your warranty and ultimately, not be able to take it back to us because you're getting us a product that we, you know, can't be confident that we would know how to for sure access, work into because of whatever third party parts you might have in it. So while I think I would definitely need to do some more thinking and research into that, it's a great question because it is currently stumping me. I think I would say right now I believe that those warranties still could be voidable in this instance, even if there is this federal Freedom to Repair Act.
Yeah, and I guess an allied question would be liability, right? And you touched on it earlier, right? The sticking your hand into the Taylor ice cream machine and then having it torn to bits. Who's going to be liable for that?
Yeah, I would probably that would certainly need to be in the discussions, and I would assume that you'd have to bear that risk if you're going to, especially, if you're going to be accessing something dangerous like that, like specifically a tractor. I mean, I think surely you have to bear that risk. But these ice cream machines too, they can get very hot when they clean and spout extremely boiling water, extremely hot water. So I think that that too is a great question and a great point that there is that also that risk, and that is also why I spoke on these reason these real concerns of these OEMs is that safety is a true concern and they don't want to be liable for people getting hurt when they try to fix their products because their products are inherently dangerous. And so maybe there needs to be more discussion about this liability that entails with giving a third party the right to repair.
No, I appreciate that. There are probably a number of other issues we haven't, neither of us have thought about that will come into play here in trying to balance the right of the manufacturer, the copyright developer against the right of the purchaser of that copyright. One thing you mentioned in the paper that I'd like to ask you about is you refer in there to the fair use doctrine. And I started off by talking about patents and exhaustion, but the fair use concept in copyright law is a little bit unique to copyright law. There's no fair use in patent law per se, but there is. It's a big deal in copyright. Can you comment on your how you understand the fair use doctrine, the interplay between the fair use doctrine in this context and the DMCA, the 1201 provision?
Sure. Yeah. It's funny. Although, Section 1201 and the DMCA is called the Digital Millennium Copyright Act, I don't know. I don't even believe it is, reason that is believed to be a copyright act. It is more of a anti-hacking act, if anything. If you look at Section 1201, it doesn't say anything about copyright actually at all. And when they were, the legislative intent behind it, they never intended for it to be a copyright law. So I think how it interplays with copyright and the thought of fair use is interesting because necessarily violating access control or circumventing, or manufacturing the tools to do so. I don't believe fair use necessarily touches because it's not necessarily a copyright law more than it is a anti-hacking law. But I think it's in conjunction to your excuse me, in conjunction with your copyrighted work. I believe that if you're, you know, bypassing these access locks with the goal of, fair use, like the Universal Studios example, that you're just doing this to, and you have the intent, the you're not making any money off of it. You're demonstrating that you only have the intent of allowing DVDs to play on Linux. I believe that that is, fair use. They're just trying to use this on your own operating system. So how it necessarily interacts with fair use is interesting, and I think there needs to be more research into that. But I think it's necessarily how once you bypass the access lock is what you intend to do past that, and how your use past that um, corresponds with our understanding of fair use.
No, I appreciate that, those thoughts. I think that is something that's worth a little more investigation. And of course, the typical fair use approach involves use of a copyrighted work for the purposes of, education, or the purposes of criticism, analysis, and those things. And uh, I'm not sure in the context of the right to repair that how fair use actually comes into play. It's why, for me as a patent attorney, it's easier to think about the exhaustion doctrine and the ability to, if you pay for it, it's yours, and then you get to do whatever you want with it. Um, and but I think what we've seen over the last 15, 20 years in court cases is that the fair use doctrine has been expanded at almost every time it has come, certainly before the Supreme Court. They have indicated a willingness to expand the concept of fair use. So I wonder if at the end of the day, a fair use approach to this might not be the way to address it. And it would also, if you thought about it some, right, addressing the definition of fair use under the Copyright Act itself, but separately from trying to solve this problem under Section 1201 under the DMCA, might be worth addressing. But it's fascinating concept. So I don't know. I've taken up an awful lot of time, and we're running right up on here 12:50. So I don't know, Professor Harmon, if you want to take this back, if you want to give other folks an opportunity to ask questions, but I'll turn the floor back over.
Thank you. Thank you, Mr. Wixon. I appreciate that. I appreciate your fascinating conversation with Sam. And Sam has obviously acquitted himself well here. He knows this topic, and he's thought about it from every angle and can think awfully well on his feet about it. I did have a couple of questions people have mailed to me through the chat, so just wanted both of you can answer this. Just a little background on this. The original purpose of of locking people out was it the questioner asked here, it was because they feared that repairmen would, reverse engineer something, that they learn something about the way these things are, these machines are built, and therefore steal the intellectual property. Was that why this was originally designed? And of course, the trouble that has come from that, we understand. But was that the original intent to lock this down so that only those that were technicians that are licensed with the patent owner have access to it?
Yeah, so the genesis of it was to protect from reverse engineering, and ultimately, as we found out, this could go a little further than just protecting yourself from reverse engineering, and they quickly found out that we can make these devices pretty technologically confusing and error code ridden. And if we error codes are locks, and if we just install a ton of locks pursuant to 1201, then no technician can get through it. And if they do, we have a case against them, or we can enjoin them and cease and desist them and whatever we want to do against them. So it did start out with this understanding that we want to protect copyright holders' interest in their materials, and we don't want it to be reverse engineered, especially with these devices that have a ton of proprietary information in them. We do not want these reverse engineered. but then it has ultimately found itself to be more used as a, a bludgeon against anyone who tries to, access this for any reason, any purpose, any, diagnostic, fair use, anything.
One thing to keep in mind is if you think back to the late 90s, or actually the earlier than that, right? The DMCA itself, in part, was a reaction to the shift to an online world, um, and the fear of copyright holders that if they put their products online, then other people were going to basically take their products and the value of their products and undermine them. And we had all of these, basically the file sharing. Um, Stuff going on with the music industry, right? Put the music
Right.
out there and then everybody's stealing it. And so, my recollection, I have to say, I was old enough to recollect that a lot of the impetus for 1201 came from that industry and not from the auto industry or the farming industry or anything like that at that time, because they weren't at the point that they're at now. They were 10 years behind that, right? So what we saw was by the the early 2000s or into the 2005, 6, 7, 8, 9, 10, the technology in these other industries caught up to the point where they started to look and say, how can we take advantage of this act to protect now what we've got in a software investment that we hadn't made back in 1998, to be honest. So that's one of the reasons that it doesn't fit as well as we might like, because it really what they weren't thinking. They were thinking about the music industry and file sharing online, trying to solve that, people getting zapping access controls in order to steal, music. But and so that's why the act perhaps does not address as well as it ought to the type of problem that Sam has so well explained and illustrated here. And so in readdressing this and in looking how can we fix this problem that we have, I mean, I think that's why there's a the opportunity to address the act and its shortcomings in this context is great, and I appreciate your encouraging Sam to move forward with the work that he's been doing on this.
Absolutely. I've got time for one more question from the chat. I wonder about this too. McDonald's is a big company. Are there so few uh, ice cream machine makers? Is it a Taylor or nobody, or are there a lot of them out there, but they're all like this? They all do this the same way. Is there nothing in the, the negotiation process where are they so powerless against this that this can't be addressed through some kind of negotiation that allows for some leeway here and that, and at least that's another way of addressing that, or is that not possible?
No, that is certainly possible. I didn't have the opportunity to look into their negotiations or their, contract or anything. I would assume it's probably just some contract issue that they have. They probably have decided to go with Taylor for the next 20 years and
Mhm.
signed that 15 years ago or something, or 40 years or something, whatever. But that, that is true. They probably could contract in this right to repair just into their contracts and say, hey, or maybe even do some sort of joint venture with Taylor and say, hey, maybe we could get some technicians to make it cheaper for everyone for
Right.
and us. So I do believe that through contracting you can certainly you can essentially contract for anything. So you can always contract these rights into that, but um, as it relates to McDonald's and why they keep going with Taylor, I couldn't tell you. It's a great question. Maybe they obviously don't make great Taylor. They don't make the best ice cream machines, obviously. So
It
uh,
does them no good for this to be. I mean, this was part of the, the Trump campaign, that I just noticed they were saying, is that we will fix the ice cream machines
yeah,
too at McDonald's. And I didn't, I mean, I never go to McDonald's to get ice cream, but I know now that they're always
yeah,
broken team
yeah, they
now.
are.
And,
They are.
it's a huge thing. And now everybody jokes about it. I said, I missed out on this. I had no idea. So,
Yeah,
so,
that's
so Sam, this has been a fascinating. We are out of time. There are a couple other questions that I'm afraid we're going to have time to go to get to, but a great topic. Obviously an important one. something you know a lot about, and as I said, have shown a great deal of acumen in addressing the questions that Mr. Wixon, you too, for helping Sam field them and to find his way through them. I think it's a very promising article, and I hope that we will have he'll have a chance to pursue this. We will certainly have a story on this presentation on our website. The video will be there for Sam, for everyone who didn't get a chance to see the live presentation, to see it later. But at any rate, we thank those that came into the audience today. We thank Mr. Wixon for responding to Sam's wonderful presentation, and Sam, thank you for being our third student scholar this year in a highly competitive award ceremony. You're one of the three, and we thank you for doing such a great job for us. So we'll now end the presentation of this year's Student Scholar Series. We'll be back next year for the 17th series, and so until then.
Thank you.
Bye.